I call David Clendon.
Thank you, Mr Speaker, and I'm pleased to take a final call on this bill to speak of support for this bill. And as we go into the final reading, it is worth noting, as others have done, the genesis, if you like, the original policy work that was done around this issue, which came from the Law Commission, who did 3 pieces of work which were linked. And the final and most substantive, I think, challenged the adequacy of the legislative regime around offending of this nature, or nuisance of this nature, if you like. And they found the legislative framework wanting, frankly, and proposed a series of options and possible remedies for that. The bill, as it has evolved, does reflect some of the proposals contained by the Law Commissions. Others have been amended, but overall it does undoubtedly plug a gap in our legislative framework. And in fact, that point was commented on by the Police Association in their very useful submission to the Select Committee on this bill, where they pointed out that they could deal with sort of the very low-level nuisance offending. They could deal with the very serious offending where actual physical threats or some sort of direct assault was made on somebody, but they also highlighted that there was a large and growing gap in the middle where they were finding it very difficult to actually bring any action against people who were undoubtedly causing grief, causing harm. I think it's important, there has been some critique that we are creating a legislative regime or some statutory framework which is unique to online content, unique to the internet or to digital communications. And I think that's entirely appropriate. I think it's somewhat disingenuous to suggest that the digital platform, if you like, the internet, is somehow not unique, not different. The reach of the internet is unique. It is pervasive, it is ubiquitous. The accessibility of the internet is unique, and it's possible to inflict considerable harm over a great distance with a very, very basic access to the internet. And I think that has to be recognised. In a sense, we've been here before, clearly in the 50s and 60s, when television became more commonplace. There was a need to have some legislative response to that, around censorship, around what we'd now recognise as broadcasting standards, those sorts of things. I recall a famous quote at the time that TV was simply another home appliance, simply a toaster that happened to have pictures on it. And of course, television did change the media landscape in the same way that the internet is changing the way we do business, changing the way we trade, changing the way we educate people, changing the way we interact socially, and that it is undoubted that it is a new medium and we need legislation fit for purpose to deal with that. So support for the bill has come from many quarters, and I would quote the Human Rights Commission, who said, and I quote, "In our view, the bill strikes the correct balance between freedom of expression and access to the internet. A right cannot be interpreted so broadly that it allows others to be harmed." And I think we can take some comfort, given the degree of concern that has been genuinely expressed in some quarters, that this bill maybe goes too far. I think the Human Rights Commission, among others, is a reasonably good judge, and in their view, we have found that correct balance. I would, just for the record, reiterate what Jacinda Ardern, the point she made in respect of the intention of this bill is absolutely not to suppress satire. It is not to suppress robust political debate. Politicians need to develop thickish skins, that's taken as a given. Cartoon, satire, these are legitimate forms of expression, of critique, and there is no appetite, I believe, within the bill, those who drafted it, who have looked at it, who are supporting it, to see any change to that environment. And I'm sure that the courts in their turn will understand that and rule accordingly. So I think it's important to note also that NetSafe, the organisation who are currently involved on, I guess, primarily as an educative basis, made the point in their supplementary submission. They commented on the number of people coming to NetSafe, having already spoken to multiple organisations and having found that there was nobody to assist them. And I do think that speaks to the need for this bill to establish a dedicated agency with some authority, limited a form of authority admittedly, but nevertheless some authority, and ultimately, if matters can't be resolved there, to go to the courts. So I think it needs to be noted that this bill, in a sense, creates a three-stage approach. The primary function, a primary function of the approved agency will be to educate. And it was one of the first steps at the select committee level taken to ensure that very clear language was put into the purpose of the bill. Fundamental to the bill is the expectation, the requirement that the approved agency will be heavily involved, and one would expect to be equally well resourced to educate around these matters, not least of all with young people, but also with people who are not so young. In the offence that on the occasion when something does occur that upsets someone, the next step, of course, after education is the mediation negotiation process, which the approved agency will seek to facilitate. And that, again, that is a good process to endeavour simply to get these matters resolved without recourse to the courts, but ultimately having the confidence that if people are unreasonable, if they cannot come to a negotiated or a mediated outcome, then the courts will step up. And again, Netscape make the point, and I quote, "You can't have part of the process and expect the full effect." The point they make is that the court process is required to make the approved agency process work. There needs to be a little bit of the threat of a stick over, sort of hanging over, if you like, the negotiation, just to focus people's minds, to ensure them, actually, this is serious stuff and will be treated accordingly in the event that, that people are not able to come to some negotiated remedy. So to speak to a couple of points again, in part to seek to allay fears or concerns that have been expressed, I think we have to be aware of the communication principles that have already been identified. There are, if my memory serves, 10 of them, and they do set the scope for the work that the court might be obliged to do, indeed that the approved agency will do. They set the criteria, they establish a framework for considering whether or not people could and should be genuinely understood as having been offended against, and to put some pressure on people causing offence to remedy that situation. The digital communication should not disclose sensitive personal information, should not be threatening, intimidating or menacing, should not be indecent or obscene, should not make false allegations. These are fairly obvious criteria that anybody could understand and respect. I'm also given some comfort by the fact that section 6(2) of the bill specifically states that in performing functions or exercising powers under this Act, the approved agency and the courts must act consistently with the rights and freedoms contained in the New Zealand Bill of Rights Act. That's an absolute clear statement that nothing done in the name of this bill or under its banner can be allowed to be inconsistent with the Bill of Rights Act, and I think that's a significant defence and one which has been perhaps overlooked. The threshold for proceeding, assuming the approved agency is not able to mediate an outcome, in the event a matter does go to the court, then there is a threshold set, and it requires the court must be satisfied that there have been threatened serious breaches or have been serious breaches or repeated breaches of one or more of the communication principles, and that the breach has caused or is likely to cause harm to some individual. So it's already a reasonably high threshold for to even get the case into the court. The court is able on its own discretion to reject anything they perceive to be frivolous, vexatious, or that doesn't meet that threshold. Section 19, again, it's not sufficient to say that harm was caused. It must also be proven that there was an intention to cause harm, that a reasonable person would expect that harm would be caused, and that in fact harm was caused to an individual. So I think we can be reasonably confident that this bill has been well thought through and does put in place some significant protections. I'll comment briefly on a matter that was brought up at a late stage the concern that in fact you might get a counterproductive outcome, that the takedown, the safe harbour provisions will take at least a number of days, and the content that might otherwise have come down immediately would in this case actually persist for some time. And there was an amendment made at the committee stage, which we entirely support, to the effect that companies who receive a complaint, rather content hosts who receive a complaint, can at their own discretion take down material that they in good faith believe is offensive or that conflicts with their terms and conditions. So, and finally, sir, I do indicate my support for this bill, and we look forward to its implementation, and certainly support the notion of an ongoing review to ensure it is achieving the outcomes we seek.